Hi, thanks so much for joining our webinar today. My name is Jessie Peterson. Today's webinar is conducted by the incredible Rebecca Hicks, a Texas construction lien law expert. Today's webinar topic is Mechanics Liens Texas Style, Deadlines and Forms of Notice to Get Paid. So without further ado, I would like to introduce the fabulous Rebecca Hicks.
Hello, everybody. How are y'all this morning? So I'm Rebecca Hicks. I'm the managing partner at Hicks Law Group, and we're a construction law firm in downtown Dallas, and we specialize in representing subcontractors and suppliers in construction industry cases, and particularly we nerd out on mechanics, liens, and bond claims. So this is one of my favorite subject matters. So I'm so sorry if I get too excited. I'm so sorry if I go over time, but this is one of the areas that I really nerd out on. So let's talk about what we're going to talk about today. We are going to, well, if you guys have questions, I think you guys are going to need to put those into the GoToWebinar chat box. So I think Jessie was going to just read those to me when you guys have questions. So please, please, please feel free to ask questions. I'd certainly rather talk about what you want to talk about rather than what I think you want to talk about. So let's get started. So first of all, Texas lien law is some of the most complicated lien law in the country, unfortunately. They did simplify it a little bit in 2021, so that's good. So I do want you guys to know you're definitely not going to be a mechanics lien expert at the end of this short session, but there's three things that I do hope you'll walk away from this session with. One, hopefully we can get clarity on what information you need so that you are locked and loaded, ready to make any sort of mechanics lien claim that you need to make. Two, you're going to know what is my deadline, and that is a very important question. If you only take one thing away from this seminar, and it is what is my deadline, I will be a happy camper. And step three, how do you perfect the claim? And that's the part that's a little more complicated. We're going to give you the basics of what those documents look like, but you're not going to be an expert at the end of a 20-minute session. So, step one, the only way you're ever going to be able to protect your rights to a mechanics lien, and we all kind of are probably clear on what a mechanics lien is. It is a claim you make against the property where construction is being done. It's similar to a mortgage, but it's just a creature of statute that says, hey, I sold product or I did work, so I added value to this construction project. So I get a claim against that property for the value that I added. Well, you can't make that claim if you don't have the right project information. And this is a challenge that we face with clients all of the time. We get claims referred to our office and they just don't know who the general contractor is. They don't know who the owner is. They don't know that construction chain. And so then it becomes a challenge to make the claim. So what do you need to know? These are the three questions that you need answers to on your project information. What project information do you need to know? What kind of project is it? And what I mean by that is who owns the project, because that's going to dictate the type of claim you make and the timing of your notice. Today, we're going to talk about one of those options. We're going to talk about if the project is owned privately. That means it's owned by a private company, such as an LLC, something like that, maybe an investment group, or maybe it's owned by an individual. If the owner of the property is a city, or a municipality, or the federal government, that's a completely different type of claim, and we're not going to talk about those today. We're going to be talking about private project claims, but you got to know who owns it, or you're never going to know if this is the right type of a claim, right? You're never going to know if it's a mechanics lien claim, as opposed to a bond claim. Then, what else do you need to know? You're going to need to know what position are you in the construction chain. So you've got to know all the way from that owner, general contractor, first tier subcontractor, all the way until you get to yourself in that construction chain. And then third, very important question is there a payment bond? Because that impacts how you assert the claim. We're not going to talk about how to assert payment bond claims today because we're time limited. And I think we might have another session scheduled in the future on payment bond claims. So stay tuned for that. So what kinds of projects can it be? It can be a private work project. So that's what we're talking about today, something that's privately owned by a private company or individuals. That means if you look in the deed records, the name on that deed is going to be a private company or an individual or a couple of individuals. If it's a state or local works project, that's not a private project. That's going to be a bonded job, separate rules apply. If it's a federal job, say work on an army base or work on a post office, those types of things, that's again, different rules apply. That's a bonded job, different rules apply. And then if it's a public-private partnership, also that's a bonded job and separate rules apply. So we're going to be talking about number one, private works projects and mechanics liens today. So what laws? The law that's applicable to a private project, something that's owned by a company or individuals, right, is the Texas Property Code, Chapter 53 of the Texas Property Code. So everything that we're going to talk about today is pulled directly from Chapter 53 of the Texas Property Code. And don't get me wrong, I don't make the rules. If I made the rules, they'd be a lot clearer. The Texas legislature makes the rules. And so some of the language is a little bit stilted, but we're going to bring it down to a level that makes it easy to understand today. So here's what I mean when I say construction chain. This is what a traditional kind of construction chain might look like. You start with the owner, that is, who owns the real property, who owns the dirt where something is being built. Then who's contracted directly with that owner. That party is usually known as the general contractor. It can also be original contractor or prime contractor. But you're looking for who's contracted with whom. So then you want to know who's contracted directly with the owner, and that's the general contractor, right? And sometimes there can be more than one general contractor, so you have to pay careful attention to that. So your real interest is who did you contract with if you're talking to someone. In some projects in these day and age, you can have a construction manager as well as a general contractor. Still, the question is, who did you contract with? If that company is contracted directly for the owner for purposes of the mechanics lien statutes, they're going to be considered a general contractor and you're going to treat them as such. So then on down the line, those contracted directly with the general contractor are going to be the first tier subcontractor, then second tier subcontractor on down the line until you get to wherever you fall. And so you need to know where you fall, because when we're sending these notices, when we're talking about sending mechanics lien notices, you're going to need to send the notice to everyone above you in that construction chain. So if you are that third tier subcontractor, notice is going to need to go to second tier, first tier, prime contractor, and owner. If you don't know who those parties are, you're going to miss somebody on your notice. It's not going to be enforceable. That's why you have to get your good project information. So is there a payment bond? Remember our questions we're asking, right? And one of those is there a payment bond? The reason why you want to know if there's a payment bond, again, today we're focused on private projects, right? For a private project, any private project in the state of Texas can be bonded. They don't have to. There's no requirement that a private project be bonded, but a private project can be bonded. If there is a payment bond, you want to know about that because you want to assert your claim against the payment bond as well. You want to make sure that your notice letters and your notice of your filed lien are going to the surety as well as the owner. So you want to know if there's a payment bond. So that's always when you're asking questions, when you're getting that project information, you want to know if there's a payment bond. There's several different kinds of payment bonds you see flying around in the construction industry these days. Used to, the only type of payment bond you would see is a payment bond posted by a general contractor for the benefit of its subcontractors and suppliers, right? But nowadays, what you're seeing is the general contractors pushing that risk down to the subcontractors. So they'll require that the first tier subcontractors put up a payment bond for the project. So there may be more than one payment bond on the project, is what I'm telling you. But the one you really want to know if it exists or not is the payment bond issued or provided by the general contractor. That's the one that's the most important. Subcontractor bonds are great. We want to make a claim against those too, but that's not going to impact your statutory rights, right? Government jobs are always bonded, whether it's state, local, whatever, those are always going to have a payment bond. So you definitely, if you're working on one of those types of jobs, you need to get the payment bond. And when I say payment bond, you need a copy of the payment bond. If at all possible, do not rely on somebody reading out a bond number for you or just providing you with a bond number and a surety name and address. I can't tell you how many times when clients have relied on that, the information that somebody provided was incorrect. Either it's the incorrect surety, it's the incorrect bond number. So you really want to make sure you actually request a copy of the payment bond, which you're entitled to as a subcontractor supplier working on that project. You're entitled to see a copy of any payment bond that exists for the project. But if you get that payment bond, you can actually verify that the information is correct, right? But for the private jobs, like we're talking about today, they can be bonded. It's project by project. It's whether that general contractor and owner negotiated that the general contractor was going to post a bond for that job or not. Some owners require it. A lot of owners do not. So it's just job by job. You're not going to know unless you ask the question. So always when you're asking that question, the question is getting your project information. Is there a payment bond? And just what is a payment bond? I know some of you, this is probably very something that you already know, but a payment bond is simply, it's almost like an insurance policy. It's really just a piece of paper, should say payment bond at the top, and it clarifies that the general contractor is going to pay its subs and suppliers. If for any reason that general contractor does not pay its subs and suppliers, then the surety has to step in and do that. You have to get your claim properly perfected for the surety to do that, and there are limitations on how much the surety ends up having to pay, but that's basically what a payment bond is. But we're going to be talking about if there is no payment bond on the project. So the majority of privately owned jobs in Texas are not bonded. I'd say probably about a third are bonded, but the rest of them that all of us work on are not bonded. So how do you perfect your claim when it's not a bonded job? And so the other thing I just wanted to mention when we're talking about bonding, just so folks a lot of times get confused about the types of bonds. If an owner requires or negotiates for a general contractor on a private job to post a bond, they normally have them post two different types of bonds. They have them post what's called a performance bond, which you don't care about, that is not for your benefit, and then the payment bond. A performance bond is a bond that's also, the general contractor is the principal, so the general contractor procures the bond, but that just means basically a representation by the general contractor that say, hey, owner, if for any reason I do not complete your job as I said I would do in my contract, this surety over here is going to come in, step in, and complete the job, perform my job for me, perform my work for me. That's why it's called a performance bond. But if you're an unpaid subcontractor or supplier, you don't care about the performance bond. That's not there for your benefit. What you care about is the payment bond. These bonds are usually issued at the same time. They look very similar. What you're going to need to do when you're asking those questions to get project information and to figure out whether the job is bonded is you're going to have to look at the top of the bond and determine whether it says payment bond or performance bond. A lot of times when you ask for a copy of the bond, they will just send you both as one PDF document. So you just scroll through and make sure you do have the one that says payment bond at the top. That's the one you care about, because that payment bond is that guarantee by the general contractor that they're going to pay their subs and suppliers. If not, the surety is going to pay. Great. So what's your best practice in verifying project information? Honestly, get the information up front. Don't wait until there's a payment issue. Don't wait until payment is 60, 90 days past due. Just for every job, make it a matter of course to gather project information. If you've got salesmen out there that are doing your sales for you, have them do it. Have your project managers, those types. We want to be able to gather that project information before you need it. People and other parties in the construction chain are always more communicative and easier to talk to before there's a problem. Gather the information up front. And here's just an example of what a job information sheet might look like. This is one that we kind of use with clients if they don't have one in place. This is just, if you were to get this job information sheet or something like it, completed on each of your jobs, you're gonna have all of the information that you may need to make a mechanics lien claim or a bond claim. And any provider like SunRay or your attorneys that you work with, if you can provide this information, you're going to be golden as far as trying to get that claim perfected. So if my recommendation is that you implement getting job information sheets on all your jobs early. How else can you verify that project information? The other way that we do it, anytime we get a bond, a lien or bond claim file into our office, honestly, what we do is we look, if the client happens to have a job information sheet, that's a great starting point. We start making phone calls and doing online research to verify that project information. You can learn a lot by just calling the contracting parties and say, who is your contract with? You remember, we're talking about, we need to know that construction chain. And the key question is who contracted with whom in that construction chain? That's a key question. You can just make those phone calls and ask those questions. Who owns the project? Is there a payment bond? One other way that you can, is very helpful in getting project information in Texas specifically, is we have a great resource, SOS Direct. It is a subscription service, so some folks don't want to use it. A lot of people aren't aware of it outside the legal field, but I wanted to draw it to your attention. One of the things that we'll talk about when we're talking about the forms of notices and the notice letter that needs to go out is you got to get it to the right address, right? One very good way to find that good address is looking at SOS Direct, that's Secretary of State Direct. It is a subscription service, but the searches cost like $1. It's very low cost, and the information that you can provide there definitely gets you a long way when you're trying to prepare these lien notices. So take a look at it. Now, we've talked about, okay, step number one, we talked about, you got your project information. Now let's talk about what is your deadline to send a notice? What do you actually, when do you have to get a notice letter out the door? In Texas at this point for mechanics liens, it is at least a two-step process. You got to get a letter, what I call a fund trapping notice letter out by the 15th day of the third month after the months that you did work or supplied product. And then you've got to get a mechanics lien on file by the 15th day of the fourth month. And I don't come up with that language, 15th day of the third month or 15th day of the fourth month. That's all our legislature. That's exactly what it says in Chapter 53 of the Texas Property Code. So what are these deadlines? It's always going to be that 15th day of the month. Now, when there was this last revision to the Texas Chapter 53 lien laws, they did add a section into the statute that if you're a normal, regular person, you would think means that if that 15th falls on the Saturday or a Sunday, that you get until the Monday after to send your notice letters or get your mechanics lien on file. But I will warn you that there's a group of lawyers that are taking that, what I think should be clear, that, hey, we get another extra day if it's on the Saturday or Sunday. And saying that, no, that's not really what that means because of this kind of stilted statutory interpretation argument. They're saying that's not what that means. So my advice to you guys still, even though, there's this section in the statute that says we may be able to wait till the Monday after, is don't do it. Just don't take that risk. We don't want you to ever be the test case that your mechanics lien is not good because you waited to the Monday and then have somebody attack it making these statutory interpretation arguments and then somehow win. I never want any of my clients or anyone that I've tried to impart this information to be the test case for them. So what does that mean? If that 15th day where you've got to send out that notice letter or get that lien filed falls on a Saturday or Sunday or legal holiday, do it early. That's always going to be the safest bet, and that's what my office does. So, okay, here is what I call a lien claim cheat sheet. And it's just listing out the different steps that different parties in the construction chain need to take to perfect a lien claim. So we're talking about what's my deadline. Let's say you're a second tier subcontractor. You've got a two-step process. You've got to send, when you see those letters FT and L, what I mean by that is fund trapping notice letter. That is how I refer to the notice letter that's got to go out on the 15th day of the 3rd month. It's got to go out on the 15th day of the 3rd month of after each month that you supply labor or materials to the job. And I will warn you here, that deadline does not run from your invoice date. It runs from the date you did the work. So if you did the work in January but invoiced it in February, that deadline starts to run from January. So now, what are we going to do? So for a second tier subcontractor, it's a 2-step process. You got to get your fund trapping notice letter out by the 15th day of the 3rd month, and then you need to get a mechanics lien affidavit filed in the real property records by the 15th day of the 4th month. Same for your first tier sub. It's a 2-step process. For those of you that have been in construction more than a minute, or at least prior to 2021, you probably recall that Texas used to have a 2nd month notice. We don't have that anymore. It used to take 3 steps for a second tier sub to perfect a claim. Now that 2nd month notice has been eliminated as of January 1st of 2021. So it's a 2-step process for anyone except the general contractor. If you happen to be in that spot where you're contracted directly with the owner, then it's a 1-step process. You've just got to get that mechanics lien on file by the 15th day of the 4th month. So here's what I call a deadline chart. And just, for all of us that were in the industry before January 1st of 2021, we used to have this 2nd month notice, and that 2nd month notice came up quick. You're talking when your invoice, your work is not even 60 days old yet, you got to get a notice letter out. That was eliminated by the legislature. Those are no longer required. The only caveat I would say there is if you happen to be working on a job that has been going on since before January 1st of 2021, which some larger jobs could be, you still are going to be bound by the law that was in effect before January 1st of 2021. You still may need to send what I call a preliminary notice or 2nd month notice. So if you're working on an older job, keep that in mind. But for most jobs, here's what we're looking at for that, for our deadlines. If you did work or supplied material in January, then you've got to get your fund trapping notice letter out. Okay, January, February, March, April. So this is how you count it. January, month 1, February, month 2, March, month 3, April. So the 15th day of the 3rd month is the 15th day of April. That's when that fund trapping notice letter has to go out. And then the deadline to file your lien affidavit is a month later. So that's going to be on file, got to be on file with the real property records by May 15th. Let me throw one other kind of curveball at you that confuses a lot of folks with regard to lien deadlines. You may have to send more than one fund trapping notice letter or more than one 15th day of the 3rd month letter, because you have to send the letter on the 15th day of the 3rd month after each month that you supply labor or materials to the job. But you only have to file one lien affidavit. So if you have to keep sending notice letters, then that pushes your deadline to file your lien affidavit farther out. The lien affidavit is only due the 15th day of the 4th month after the last time you supplied labor and materials on the job. So keep that in mind. The whole big point there is they don't want folks to have to keep filing repeated mechanics lien affidavits in the real property records if they're still supplying on the job. Obviously, you want to watch that. If you're still continuing to do work or supply on a job and you're not getting paid, that's obviously not a good thing. So you want to think that over, but you should not have to file more than one lien. The other thing to keep in line with these deadlines is that they are deadlines. That means if you send it later than the date that you're required to, the notice will not be effective. You will not have a valid mechanics lien, and you're out of luck. But you can always send it early. Do not hesitate to send a notice early if you think it's going to get you paid. If you think there's a problem and the parties up above you in the construction chain need notice now, don't hesitate to send it early. If there's a reason why you don't want to wait until the 15th day of the fourth month to file that lien affidavit, you can always file it early. Too early is only if your invoices aren't due yet. So as a subcontractor, these are your two deadlines. You got to get that fund trapping notice letter out by the 15th day of the third month, and then the lien affidavit on file on the 15th day of the fourth month after the last month that you supplied labor or materials. When you file a mechanics lien of record, you've also got to send out notice that you filed it. The step one in the process, the fund trapping notice letter, is just a letter that goes out by certified mail, return receipt requested, and yes, it does have to go out by certified mail. But the lien affidavit itself is a document that is signed before a notary, sworn, and has to be filed with the real property records in the county where your project is taking place. So once that's filed, you do have 5 days after it's filed to send notice of the filed lien affidavit, again, to all those parties above you in the construction chain. So you do have to send that notice after the filing, but the filing date is very important. So if you happen to be in that position where you're the general contractor or prime contractor, meaning you're contracted directly with the owner on a construction project, the only step you have to do is file that lien affidavit by the 15th day of the fourth month after the last day you did work on the job, and also send out that notice of the filing within the 5 days. And general contractors also have kind of this ambiguous concept called a constitutional lien in Texas. We have a lien that we have two different types of liens when you sit in that general contractor position. We have the statutory lien, which is mostly what we're talking about today, where the 15th day of the fourth month applies and the fund trapping notice letter requirement applies. But there's also this creature of our Texas Constitution, and it only applies if you're contracted directly with the owner, where you have a claim that's called a constitutional lien. So if you ever happen to miss a deadline and you're in that general contractor position, you've got that contract directly with the owner, you may be able to make a constitutional lien claim. And so it's something that you would want to ask your legal professionals that you work with about, should you ever be in a situation where you've missed a deadline. So here's our steps one more time. Third month notice, got to go out after each month you're performing the work. Fourth month, 15th day, get that mechanics lien recorded in the real property records. Within 5 days of that, you got to send notice of your filed mechanics lien. And if the lien gets paid, you sign a release. If it's not, you've got to foreclose that lien within 1 year. And when I say foreclose the lien, that means you actually have to file a lawsuit to foreclose the lien. It's not something that you can just do without, it's not something you can just do yourself. You do have to file a lawsuit to foreclose, so you will have to engage legal counsel at that point. So don't let that mechanics lien get more than 1 year old, is the point. So let's talk about, now we've talked about how to get your project information. What's my deadline? Very important question. And now let's talk about, okay, what do these notices look like that I'm talking about? Well, we now have, as of January 1st of 2021, we have a statutory form for a third month notice. So for that fund trapping notice letter, what I'm noting is FTNL, that notice letter that's got to go out by the 15th day of the third month. The Texas legislature, as of January 1st, 2021, said, hey, this notice letter needs to look like this. So you're going to want to make sure that you're using the statutory form. The next few slides are language taken directly from Chapter 53, where the legislature told us exactly what these notices need to say and look like. In fact, there is a provision in this statute that says that if you send a notice that is not in substantial compliance with the form provided by the Texas legislature, it's probably not effective. It's not going to be effective. So if you are still using an old letter that you've been using for the last 5 years or so, or maybe even longer, take a very careful look at it. Because the Texas legislature, when they provide us a form, they expect us to use it. And so if you're not using the statutory form for a 15th day of the third month notice, please, please, please reach out to SunRay. talk with them about whether they can help you with getting your form letters out, but you need to be using the statutory form. I don't care if the form you are using contains a lot of the same information. It's just kind of in a different order. Do not take that chance. They gave us a form for a reason. The legislature wants us to use it. I would use exactly the language that this legislature has provided. So this is kind of the language directly from the statute for the first part of the notice. So pretty self-explanatory, right? That warning language needs to be on your letter. The date, obviously, project description. With project description, normally what we're striving to do on our notice letters is have whatever the title to the project is and the project address is good enough for these notice letters. When you get to the mechanics lien phase, you do need a legal description, but for purposes of a fund trapping notice letter, a project name and an address are going to be just fine. Obviously, you want to get the claimant's name, so that means whoever's making the claim. So that'd be you, your company name. What else does this form say we need to do? You've got to describe the type of labor or material provided, and that can be just a general description. For example, provided painting and tape and bed services, or provided electrical work. That's going to be fine for the type of labor or material provided. Here, you've got to have the original contractor's name. So now we're back to, hey, do I have good project information? If you don't know who the original contractor is, you can't fill out the form for the legislator wants you to fill out because you don't know who the original contractor is. One of the common mistakes that we see with clients trying to fill out these forms is they just assume their customer is the original contractor and put their name in that blank when there actually is a general contractor. And so that notice is not effective because the original contractor is not named correctly and didn't receive a copy of the notice. Then you also need to put the party with whom you contracted with, if different than the original contractor, your claim amount, your claimant's contact person, and don't ask me why the legislature did that, but notice they've got your claimant name at one point in the form, and then later on in the form, they've got a separate part where they want the claimant's contact person. So there's two different spots where you need to be putting that information as far as your claimant name, right? Especially who that contact person is. And then the claimant's address is also separated out in the form. So just follow the form is my advice. If you look at Chapter 53, you're going to be able to find, if you just Google Texas Property Code Chapter 53 Fund Trapping Notice Letter Form or 50th day of the third month form, you're going to be able to find what I'm talking about. And SunRay uses them, and SunRay can help you with that. So who gets the notice? Anyone above you in that construction chain gets that notice. So the form letter needs to go out by certified mail, return receipt requested, to the owner. So what address are you going to send it to for the owner? A lot of folks will just try to look it up on CAD, and many times that's fine. But let me give you a word of caution. CAD can be at least a year, if not more, behind if a property changes ownership. Because CAD is only updated once a year when it's tax time. The true judge of who owns a piece of property is the deed records. Most counties have their deed records are online now. You can search deed records, you can find deeds. An easy way to do it is if you look at the CAD, you can often get a property number and then search by that in the deed records. But who owns the property is going to be governed by who's on the deed, not who's identified on CAD, right? You want to look up that deed and get the best practice, look up the deed and get the address from the deed for the owner on there. Your job information sheet also is helpful. When I talked about getting addresses for the owner, once you verify the ownership, you can also run that through that Secretary of State website, the SOS Direct website, and that's going to give you what the Secretary of State considers a good address for that owner entity. You'd have a registered agent and a principal place of business identified there as well. For the GC, same thing. You're going to be sending it to the address for, the good address for the GC from your job information sheet. If you can get the registered agent from the SOS Direct website, get it in there. Principal place of business, that's what you're going to want to do. For my office, what we also do is we send these notices to any email addresses that we have as well, because our theory is the more desks these notice letters hit at this general contractor or owner's office, the more likely it is that you're going to get paid, you're going to get somebody's attention that gets the money flowing on the job. So we also send the notices by email. But email is not effective notice. You do have to send the letter certified mail return requested. But if you also want to send by email, more power to you, go for it. That's what my office does. So forms of delivery for the notice. You can't use registered mail. I don't think anybody was using it, but in January 1st of 2021, the legislator said no more registered mail, but I don't think anybody was doing that anyways. Certified mail return receipt requested is the best way to go about it because it's the most cost effective. If you wanted to send your notice by FedEx or UPS, you can. The legislature in January 1st of 2021 says, hey, well, instead of just using certified mail, you can use these other receipted delivery services, but they're a lot more expensive than just sending it certified mail return receipt requested. So certified mail is still the way to go. Still no email, but like I said, you can still send the notice by email as well as certified mail, because let's face it, it's going to get there faster, get their attention faster, and business is done by email. We all know that. Unfortunately, the legislature didn't help us there. So our next step, you got to file your mechanics lien, and that gets filed with the county clerk and recorded in the real property records. If you're not familiar with recording things, this can be a little daunting, but there's generally, if you look up the real property records for whatever county where your project is, you're going to be able to Google and find the county clerk's office and determine who deals with the real property records. And most of the times, if you just call and talk with those clerks, they can walk you through what you need to do. Now, my office has accounts with several different services so that we can electronically record mechanics liens. You do have to have a subscription to those services in order and go through a process to get that subscription to be able to e-record, what we call e-record. If you do not have that, you're going to have an original signature on a mechanics lien in order to get it recorded. They're going to want a notarized original signature on that mechanics lien for them to accept it for recording. And you'd have to actually physically get it there, either by Federal Express, or if you want to hand deliver it. Most county clerks still will accept hand deliveries on mechanics liens. So that's the ways that you can get it to them for recording. But it is something that there's the real property records. They're usually housed in the courthouse or near the courthouse in most counties. So you're going to be, getting something to the real property records for recording. There's a recording fee that you're going to have to figure out what it is, and you have to pay that at the time of recording, or they will not record it for you. So the best way to figure out how to do that is make some phone calls to the county clerks and the real property records division particularly, and just ask so that you can make sure that you don't make a mistake. Some counties in Texas, unfortunately, still don't allow e-recording, which is the bane of myself and my staff's existence. Every once in a while, I'd say probably once every couple of months, we bump into one of the rural counties where we cannot just upload a mechanics lien for recording and still have to get the physical copy over there by the 15th or even before, depending on how long it takes them to record things. So be aware in advance as to whether the county you're trying to record in allows e-recording or not. So now let's talk about what does that mechanics lien affidavit look like. And this is the requirements directly from Chapter 53 of the Texas Property Code. So it's an affidavit. So what that means is it is sworn. It is something that someone with personal knowledge needs to sign before a notary public, swearing that it is true and correct. So if you don't know, if you're not sure if the information is accurate, don't sign it. You do need to be someone that has knowledge of the information provided. You've got to have the name and the last known address of the owner, general statement of the type of work you've done, the name and last known address of the person who you contracted with. So a lot of the same information that you're already going to have from your prior notice, your fund trapping notice letter. The part that's going to be different and a little harder to find or get is for your mechanics lien affidavit, you do need a legal description for the property. So you remember when we were talking about your notice letter and you're talking about your project, it's fine to just put a project name and a project address. That may be okay for a mechanics lien, but the gold standard is you need a legal description. That means when you look at a CAD, the CAD record for a particular property, a lot of times you'll see what's called a lot and block number. That's part of a legal description. A legal description is a meets and bounds, so it's this kind of very arcane description of exactly the borders and the dimensions of that piece of property. If you ever look at a deed, even the deed for your house, what you'll see is that it describes it in a from here, thenceforth here, thenceforth here. That's where you need to be looking at the deed records to try to get that legal description if you want to make darn sure that your mechanics lien is properly recorded. So that's the only kind of more challenging part to getting this mechanics lien affidavit correct, is getting that legal description in there. And so all of these kind of areas of information are what has to be recorded, has to be covered in your mechanics lien. The Texas legislature did not provide us a quote unquote statutory form for an affidavit for mechanics lien. So there is no quote unquote statutory form, but this is just a listing of all of the information that has to be provided in that document for it to be enforceable. So you just need to make sure that all of this information is in your affidavit for mechanics lien. And here's just a couple of the services that we use. If you wanted to take a look at being able to e-record yourself, it's a couple of the services that we use. They don't do anything for you. You have to have, the affidavit has to be ready to go. You have to have an established relationship with the provider. And then all they do is you upload the document and they take care of making sure it goes to the county and whether it's accepted or not. So they're not a SunRay. They don't help you out with content, none of that. It's just, if you want to try to go it alone, this is how you might be able to do it. And so then after you've gotten that affidavit for mechanics lien recorded, you do have to send out that notice of the filed mechanics lien within 5 days. And what we do is we just slap a cover letter on it that says enclosed is a copy of a mechanics lien that was recorded on whatever date, and then we send it to all of those parties via certified mail, return receipt requested. All the parties in the construction chain get it. That's all that's required. But that does need to go out within 5 days of the date that lien was recorded with the real property records. And when I say recorded, what that means is the county clerks accept your document, this affidavit for mechanics lien, they accept it, they file stamp it, and then they actually index it so that it attaches to that piece of real property. So then if you look up that piece of real property online, what you're going to see is that now you see your mechanics lien as well. And one other great way to do project research is to look at these real property records and look for other mechanics liens that have been filed against the property. That can be very enlightening as far as who has a claim outstanding and who the parties in the chain are. So that's really all of the comments I had for today. Hopefully I didn't go too far over, but if there's questions, I'll be happy to answer them.
First of all, Rebecca, thank you so much. You really were incredible. That was a wonderful webinar. There's a lot of information out there for us, so I appreciate all that you did. We have a couple of questions that have come through. The first one, it says, hi, thank you so much for this information. It was very helpful. What if there is a notice of commencement filed? Do we need to add the recipients from the NOC?
Absolutely would, yes, because the more desks that notice letter hits, then the more likely you are to get paid. And also that's a very good representation of who the right parties are, right? The notice of commencement should properly identify the general contractor and should properly identify the owner. So yes, I absolutely would. That's a great suggestion.
Perfect, thank you so much. And then it says, why are residential notices sent at different times than commercial projects?
Because our legislature wants to make our life difficult. What we just talked about, and that's a very good point, so I'm so glad somebody asked that question. My office does not really do residential notices, so we really focus on educating folks in the commercial space. So if you are doing residential work, the deadlines are 1 month sooner. So you're going to have to send your notice letter sooner, and you're going to have to file your lien sooner. And the reason for that is because Texas is very, very strict about protecting homesteads. You guys probably understand that, you can move to Texas and gold plate your floors to avoid your creditors, because we're going to ironclad protect your homestead. The reason why the rules are more difficult and harder for residential are because they want to protect the places people live. Now, when I'm saying residential, I mean something that's owned by an individual. It's work that you're providing for a homeowner that either lives in the home or intends to live in the home when it's completed. I'm not talking about when we're talking about a residential subdivision that's under development, that's still owned by a developer. That commercial rules apply to that. So you're still talking about 15th day of the 3rd month, 15th day of the 4th month if it's a residential subdivision. But if you're actually doing work on someone's home or building a home that is going to be owned and occupied by individuals, then those stricter deadlines apply. And there's all sorts of other requirements as well. You've got to have a contract that says a bunch of different stuff, and it's got to be signed by both the husband and the wife if it's a couple. And if you don't do all the contract stuff up front, then you still don't have a good lien. So it's the residential ball game is just a completely different ball game, and it's unfortunately a lot harder. So
Okay,
that's my
wonderful.
very long answer.
Thank you. And then we have the next one. It says, hold on, my screen just switched. Let me move it back there. What if there is a lender, but they didn't receive a copy of the notice?
Lender doesn't have to receive a copy of the notice.
Okay, wonderful.
You can't. There's nothing wrong with sending a copy of the notice to the lender. That's fine. But as far as strict compliance with Texas lien law, as far as sending out your fund trapping notice letter, lender doesn't have to receive a copy.
Okay, wonderful. Another question that came through, it says, thank you for the information today. In a case where there may have been equipment installed and invoiced in monthly installments, how do the notices work? The work would be done in 1 or 2 days, but invoiced every month.
Your lien filing deadline is going to run from the date you did that installation. We don't care about the billing dates. So your deadlines will run from the date you install. That's going to the tricky part with that kind of arrangement is if your payments aren't due yet, that's going to be hard. But yeah, you're going to need to, the deadlines are always going to run from the date you did the installation and did the work.
Perfect. Another question that was posed, it says, why aren't NOCs required? So why isn't a notice of commencement required?
Because our Texas legislature doesn't require them. That's why. This last round, well, for the last, I would say at least 15 years probably, we've been trying to get some modernization laws through the Texas legislature. One of those would be, you probably may have heard of other states where they have kind of a website where everything on a project is governed by a central website. So if you need to send a notice, you just have to log on, find your project, and hey, I'm out here, which is seems a lot easier. We tried to get some of that information, that kind of a thing, through the Texas legislature, and it just did not get through. All we got through were those changes, getting rid of the 2nd month notice, which was a good change, and a little very small kind of incremental changes. So the reason why a notice of commencement is not required is because the Texas legislature says that it's not.
All right, another question that was posed, it says, do I base my notices off of my invoice date? I believe you just touched on this, or the actual last day we were on the job? That is where I get confused as to which date to go off of. We might have a few different invoices throughout the project.
Yeah, and this is where you may have to send more than one notice, right? If you have invoices for more than 1 month, you may need to send more than one fund trapping notice letter, because your deadline for sending that 15th day of the 3rd month notice letter goes from the date you did the work, not your invoice date. So it's going to be, what date did my product hit the job? What date did I do the work? And so if you happen to invoice the month later, your deadline didn't just get pushed a month. You've got to go from the date that you actually did the work or the date the product was delivered to the job site. That's when that deadline runs from.
Wonderful. Another question that was asked, you've got a whole slew of them here, so bear with us. It says, we were wondering if you have any information on filing liens for retainages.
For retainage, yes. For some of the changes to the Texas legislature, this is where, we can't cover everything in 20 minutes, right? But some of the changes that got through with the January 1st, 2021 changes to Chapter 53 changed the deadline for getting a lien on file for retainage. That deadline, you do need to get a notice letter out by the 30th day from the date the project is completed, or the date your work, at least on the project, is completed. And then your lien affidavit has to be on file after that. So normally when you're talking about retainage, my best recommendation is just get that lien on file within 30 days. If you're completed on the job and the job is completed, don't let that 30-day deadline pass. Get that lien on file for retainage. And just so you know, the legislature actually changed the phrasing on it. It's no longer even called, they don't want to call it retainage anymore. They call it reserved funds now in the statute. So what we used to call statutory retainage is now quote unquote reserved funds. So that's that 10% held by the owner till the end of the job. And your best bet on that to make sure that you never miss a deadline is to just get it on file within 30 days of the end of that job.
Perfect. I think that is pretty much all of it. I know there's a question that was posted on here as to will the webinar and forms be sent? Yes, so after this webinar, we will make sure that we get you over this information to you. I will reach out to you. Let me see here. It says, I could be on this webinar all day. It was just fabulous. Thank you again. All right, I think that's all the questions that have come through. If anyone does think of another question that wasn't addressed, please feel free to reach out to me. I will be sure to answer any questions as soon as possible for you. Rebecca, can you go to the next slide for me, please? All right, so we are going to test your knowledge. So who's ready to get a little gift? Take a look at these questions on here. If you feel like you know the answer to them, I know Rebecca has gone through this information. So if you feel like you understand the information, chime in the chat, and we will make sure we send over a little gift to you as a thank you. So go ahead and take a look. It says, in Texas, who must be a residential notice letter to owner and original contractor to trap funds monthly after 2 months on a residential project. And then the other question is, on a commercial project, when is the deadline to file a Texas affidavit of mechanics and materialness lien? So take a look at that. If you feel like you know that answer, go ahead and chime in. I see a couple of answers coming in, so I will be reaching out to you guys after the webinar. All right, can you go ahead and go over to the next slide for me, please? All right, so here are some of SunRay's resources to help you guys stay organized, know your deadlines, and secure your lien rights. Go ahead, scan this QR code to access these. We have a free project information sheet, as Rebecca was kind of showing, that really helps get you guys your information that you need at the start of your project to make sure that you guys are protecting yourselves. There are deadline calculators available. There's the state lien laws. So if you're working in a neighboring state and might not know the information, or even if you're working in Texas and get a little confused or turned around, it will break it down for you as to what type of project it is, what your role is on the project, and what documents are required at that point in the deadlines associated. So scan that QR code to access these resources. Go to the next slide, please. All right, we have a new service available at SunRay. It's SR Receivables. We're going to help get you guys paid and handle your collections for you. So if you are in need of some information, please reach out, give us a call, send us an email. We'd love to be able to help you guys out. Next slide, please. All right, our next webinar with Rebecca is going to be Payment Bond Claims, the Basics. That's going to be on October 30th at 10 a.m. Eastern. So go ahead and sign up for free at sunraynotice.com/education. We hope to see you guys there. Next slide, please. All right, if you don't mind, take a moment just to review us on Google, scan that QR code. We really appreciate any feedback we can be given. It helps us always improve our webinars and make sure that we're getting more information out to contractors and suppliers like yourselves. And then the next slide, if you don't mind. All right, and with that, that is all we have for you guys. Thank you so much for everybody who attended. We hope to see you at our next webinar. Thank you again, Rebecca, for everything. I hope you all have a wonderful and beautiful sunny day. Thanks, everyone. Bye-bye.
Bye, everyone.